In this segment, we get into a discourse on a very special ecosystem which are referred to as ecologically sensitive zones, a nomenclature that does not find expression in the original Environment Protection Act but makes an appearance only a few years back thanks to judicial interventions in India. But before that, some of the basic things about ecological sensitive zones. These are areas which extend up to about 10 kilometers around protected areas like national parks or sanctuaries, and they are declared as such through a notification of the Ministry of Environment, Forest and Climate Change. What's the purpose behind such a kind of a declaration? The idea is to create a buffer, a kind of a shock absorber for those very protected areas which in its neighborhood, if it is not properly taken care of, would adversely impact on the very integrity of these protected areas. In a way, these areas act as transitional zones from areas of high protection to the ones with less protection. They also help in situ conservation some of the rare endangered species in their natural habitat, like rhino or the Kaziranga National Park, and they minimize the depletion of the forest cover and also to a large extent reduce man-animal conflict, which is one of the major problems we have in India. And this is essentially based upon the core and buffer model of management of protected areas, in which local communities are also given an opportunity of, number one, protection and also getting benefit. Although it does not have a kind of a legal origin in terms of a statutory formulation under the Protection Act concerning environment, its origin can be traced to a number of cases decided by the higher judiciary which expressed concerns about the safety, security and protection of forest and wildlife and their immediate neighborhood when intensive developments take place in their close proximity. The courts of law have invariably exercised caution by insisting on the government to follow some of its directions for the protection of these core protected areas and insulate them from developmental activities. Of course, around the year 2002, following a series of High Court and Supreme Court orders in this regard, the Government of India came up with what is called as the Wildlife Conservation Strategy in the year 2002, and this desires a notification to be issued about areas which come within 10 kilometers of the boundaries of national parks and sanctuaries to be declared as eco-fragile zones under Section 3, Clause 5 of Environment Protection Act and the rules under the Act. The state governments, the strategy required, they were required to prepare a list of such areas and furnish details of them to be notified as eco-sensitive areas. Look at that. Two nomenclatures were used. Eco-fragile zones or EFZ or eco-sensitive areas ESA. And the states did not promptly respond because the conservation area with its expansion, developmental activities would get shrunken. So they had their own reservations, and so they did not promptly respond to them. But the strategy insisted that this is very much needed because the areas outside it protect areas are vital corridors that link those wildlife that is there between two or three protected areas, and that would prevent isolation and ensure survival of fragments of biodiversity in the long run. Even the National Wildlife Action Plan that was unveiled in the year 2002 for a period of 5 years indicated the need for land and water use policies to strictly protect these EFAs and regulate use of land and water for any developmental activity in the area. They also indicated that such identified areas be declared as EFAs under the EPA. There was another public interest litigation filed by Goa Foundation, and the Supreme Court, on hearing this petition about lack of response or poor response by the states to the umpteen number of entreaties by the central government in this regard, it required the ministry to once again give another opportunity for the states to respond to the requirement of submitting proposals for declaration of ESA for identified areas by them. And only a few states responded. And in two major landmark cases, T.N. Godavarman and Anand Arya, two cases decided by the Supreme Court in 2010, Supreme Court took note of this laxity of response by the states, directed the center to issue guidelines for the purpose and give effect to the idea of a special conservation regime. And then subsequently, there was yet another order by the Supreme Court on being informed of by the central government of receipt of proposal by the state that out of the sanctuaries and national parks that we have, which number around 662, 641 proposals are received. The rest they are yet to give. The court directed the center to declare 10 kilometers around even the remaining protected areas as ESZ as well. So all this led to a series of notifications being issued by the central government, notifications on ecologically sensitive zones, and over a period of time by around 2019, the ministry has issued notifications covering 316 protected areas and draft notifications covering another 199 protected areas under this provision, and a set of guidelines also were issued from time to time for that purpose. What do? These guidelines lay out the criteria on which the areas can be declared as ESZ, ecologically sensitive zones, on the basis of number one, species based on their endemism or rarity, or uniqueness of the ecosystem, like sacred groves or frontier forests, or unique geomorphological feature that they exhibit, like an uninhabited island or the birth of a river, that ecosystem, that kind of thing. And through each notification, identified projects or activities were regulated or prohibited, as the case may be, in a site-specific manner for the conservation and sustainable development of the notified areas. A zonal master plan should be prepared by the states on a scientific basis with adequate participation of local communities and the line departments of the state government. This is the requirement of the guideline. In specific terms, if you look into the guidelines that are issued, they refer to the conditions laid down under the guidelines under three heads: prohibited areas or prohibited activities like commercial mining, establishment of sawmills, prohibited, and so many other activities of that kind. regulated activities like felling of trees, establishment of hotels, etc. And third, permitted activities which relate to agriculture or ongoing agricultural or horticultural practices, rainwater harvesting, something which is conservation oriented and which is least harmful for these eco-sensitive zones. Guidelines are issued by the center and the implementation is always done at the state level. The regulations and the guidelines are very impressive. And this is what the states are supposed to put that into application. But whatever the grandiloquence of these guidelines, the real monitoring and the real-time compliance, its implementation, which are in the hands of the state government, are not that very impressive. It is still to come to the expectations of the guidelines that are laid down in this regard.